Hi, my name is Seon. I'm Senior Privacy Counsel and Head of Policy at Inpher. We are a privacy-preserving machine learning company that believes that privacy and security are foundational to the future of computing. Thane?
My name is Thane Bauz. I'm founder of Bauz IP Law. It's an alternative law platform. And today I'm here to speak about the intellectual property aspects of big data.
Great. So before we go in, when you open up news about privacy, you will probably encounter the following cliches: that data is the new oil, that consumers don't care about privacy, and that privacy regulation hinders innovation. We want to move away from these cliches to have a more thoughtful discussion about the law and policy surrounding technology. So we cannot treat data as a commodity like any other because it poses real externalities on societal well-being, individual rights, and international relations. And hopefully, by having a conversation about the policy and impact of regulations, we can move towards a reform where the power dynamics are put back into the hands of the consumer to access their data and control their information with better regulations than we currently have now. And secondly, it's important to recognize the importance of privacy by design. Innovation can actually embrace privacy-enhancing technologies that can be standardized as ex-ante safeguards to prevent breaches rather than just reacting to them. And we're going to talk more about privacy by design and different methods and how to bridge law and technology to arrive at a better regulatory framework for privacy. So why don't we talk a little bit about the current regulatory landscape in the US, how it compares to the EU, the normative divergences that we have, and also the intersection of privacy and AI. So in the United States, we have a more sectoral framework for privacy, whereas in the EU, they have an omnibus law like the EU General Data Protection Regulation, GDPR. I talk about the contrast between them because it makes a big difference on how enforcement agencies deal with regulating big tech, and because technology is becoming a more international issue as social media platforms collect data from all around the world and use it for processing, it's become a very relevant topic to talk about the differences today. So in the US, the Federal Trade Commission, the FTC, has some jurisdiction over privacy, but it is not an independent privacy regulator. They have sectoral regulatory jurisdiction over children's privacy, COPPA, financial institution data with the Gramm-Leach-Bliley Act, and a more de facto broad authority under Section 5 of the FTC Act to prosecute unfair and deceptive practices. Currently, Facebook and Google, amongst other technology startups, are regulated under consent decrees that arise out of settlements from complaints about unfair and deceptive practice. So for example, if Facebook was to override a privacy policy and collect more data than the user originally agreed to, that would be an unfair and deceptive practice. If Google was to manipulate the user interface to manipulate consent and also collect more data and use secondary processing without giving full notice, that would also be something that the FTC would have a right to impose a consent decree on. And once the FTC gets this type of settlement, they are allowed to impose a term of 20 years of more proactive monitoring with a third-party auditor on the respondent to fundamentally change their practices. Now, why don't you go into the IP details more, and I'll finish up with a little bit more AI implications.
Okay, thank you, Sunny. Just within a few years, there will be 75 billion devices attached to the internet. That's approximately 10 per every person living on the earth. They would probably generate a business of $103 billion a year. That's a lot. You might want to think about investing in Sunny's company. And at this point, only 0.5% of that data is being analyzed. So while Sunny's talking about the privacy aspects, I'm interested in the intellectual property aspects. That's exciting. While privacy starts with some trepidation, intellectual property is exciting. Let's start with an analogy. A law student walks into a library with a specific set of issues on his or her mind, goes in the library, looks at different reporters, looks at different publications, different cases, formulates the answers, walks out of the library. What can be done about that? The law student has walked out with analytics concerning the big data. So we look at intellectual property, patent, trademark, copyright, and there's other forms, of course. For patents, it's a round peg for a square hole. The first act involving statutes was 1634 in England. It's called the Statute of Monopolies. The problem is patents are round pegs for a square hole, as I said. They're not designed to handle this problem. The Supreme Court's decision in Alice is the case in point. Copyright, the EU has tried to analyze this problem, database rights. They've been unsuccessful, mostly because at the time data was kept in a structured format. Now it's distributed. It doesn't really apply to the investment made to build a database. Trade secrets, of course, not, because it's public. So what can you do when that law student walks out of the library with that big data information that's analyzed? Well, it looks like the only thing at this time that you can do is enter into a contract with that student to determine what the royalties should be. And I'm not suggesting that law schools should start charging for this, but I'm suggesting it's a problem for intellectual property that currently doesn't have an exact answer. I believe it'll be coming in the near future in a sui generis right, but right now there are no answers except in licensing law. I think in licensing, you really need to think about royalties, you need to think about caps on liability, and of course, ownership. Sunny?
So let's talk about data transfers and current safeguards that we have. Current regulations focus on obtaining consent from the data subject to transfer data and also contractual safeguards. However, these are merely operational policies that can be easily overridden by bad actors seeking to breach security of the system, which is why it's important to talk about privacy-enhancing techniques like differential privacy, homomorphic encryption, and secure multi-party computation, which keep data resident and secure in analytics. Currently, regulations don't address specific requirements for privacy by design, but it's something that a lot of proposals are pointing at so far. Now, when we go into the age of AI, we often talk about AI as a way to replace jobs, but we don't really focus on how AI is being used as a proxy for human judgment, and because of this, it can hide bias and profiling impacts under the guise of technological objectivity. This is really important to deal with because AI is very multidisciplinary, and to train it and to validate the results so that it's not replicating patterns of societal discrimination and marginalization, privacy-enhancing technologies are relevant and they're starting to become necessary. So to end up, I'm going to give you 3 R's to think about. Firstly is reform. We're going towards reform in Congress to achieve a highest common denominator of data protection. American companies are going to have to reckon with the fact that the GDPR is happening and a lot of stronger state regulations like the CCPA is also going to be relevant to comply with. Secondly, restraint. Refrain from data maximization. Try to collect less data than you need and try to be transparent about the purposes for which you are collecting the data. And finally, redress. Currently, consumers don't have a lot of actionable rights to realize their privacy rights. And that's something that companies will have to help out on helping increase access and informational self-determination so that we can all live in a society where privacy becomes less of an issue and is a way to exercise autonomy and self-individualization. Thank you.
I think there's one other point with regards to judgment. Think about the robo-lawyer. Well, that's probably not going to happen. What might happen is the C-suite of companies might be second-guessing their lawyers. Remember, Cal Bar Ethical Rule 1-300 puts a prohibition on unauthorized practice of law. It's something that lawyers need to think about in this age of artificial intelligence. Thank you very much.